News that we are breaking to you. The Supreme Court directs RBI to withdraw its 2016 policy on non-disclosure of information pertaining to big loan defaulters of the banks controlled and regulated by it. The Supreme Court gave a last opportunity to the Reserve Bank of India to comply with its December 16, 2015 judgment on the disclosure of information. Meenakshi Bhanja joining us on the phone line. Meenakshi, can you help us understand the latest directive that the Supreme Court has given to the RBI and also reminding them of the deadline?
Well, that's right, Afrida. This is a huge boost towards transparency, or rather furthering the cause of transparency, where the Supreme Court has today held, like you rightly pointed out, that RBI can't refuse to put out in public domain the annual inspection reports of banks like ICICI, Axis, HDFC, State Bank of India, and the banks, remember, including the RBI, had taken an argument before the Supreme Court that client confidentiality could be compromised if such information is put out in the public domain. And on two occasions, at least, the Supreme Court has not found much resonance with this set of arguments, and therefore today a last and final opportunity is being given to the Supreme Court, is being given to the RBI, beg your pardon, by the top court to go ahead and amend its earlier position pertaining to disclosure of such details of banks and put it out in public domain. Now, earlier there was a CIC ruling too to this effect, which was not being complied with by the RBI, and subsequent to that, there have been directions that have come by from the top court, which again RBI has been found to be non-compliant of. Therefore, these directions today assume a lot of importance, because now RBI is duty bound to comply with it or face contempt charges.
Meenakshi, thanks for joining us with that information and for giving us a clear perspective on this.